Preborn life falls through the judicial cracks. Good morning, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. Earlier this week, the United States Supreme Court quietly let stand a state Supreme Court ruling that a preborn child is not a person. The case at hand is the first case, at least since Dobbs v. Jackson Women's, to challenge a state law permitting women to end their pregnancies on the grounds of equal protection of the laws. We know only that 3 or fewer justices would have granted certiorari in the case, because none of them filed any dissents. So I want to talk about that case in detail and explain why other plaintiffs should try again and again until the Supreme Court faces squarely whether the Constitution of the United States grants a right to life. Before I begin, I do want to shout out to the prime sponsor of this channel, which is Conservative News and Views. Link in the description. Be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. You'll find lots of good merchandise there, including this t-shirt that I have chosen for today, which depicts a preborn child. Note in the womb. Note the umbilical cord. And this caption, not your body, not your choice. That's because, as I have said before, the time to make a choice is before conception, not afterward. I do hear, incidentally, that urologists, who are the nearest thing to andrologists that the medical profession has, are performing 3 times as many male sterilization operations on their male patients as they ever did before. Well, that's one way to avoid the problem. Not the way that I would recommend, but at least it's a way that does not destroy life, to paraphrase Mr. Justice Samuel A. Alito. More on him in a moment. One more thing. If you like what you're about to hear, you can like this video. You can also click the bell icon to get a notice every time I come out with a new one. In fact, you see the new icon, the heart shape with the US dollar sign in it? That's the super thanks icon. If you really want to keep these videos coming, click on that and leave me a tip. Any currency will do. Now, reportage on this sad case comes from Forbes magazine and Steve Ertel's Life News. From these reports came the case name, and with that I could search the order list for the court docket entry. The case at hand is Jane Doe et al. Versus Daniel McKee, docket number 22-201, to which I've left a link in the description. The Daniel McKee, by the way, happens to be the governor of Rhode Island. The docket listing gives a terse summary of the proceedings. Yeah, here we are. 2 adult women sued the state of Rhode Island on behalf of 2 preborn children to overturn Rhode Island's Reproductive Privacy Act of 2019, or the RPA. Catholics for Life, doing business as Servants of Christ for Life, joined them in the suit. Mr. Michael Benson, another citizen of Rhode Island, also joined, alleging that the RPA presumed to amend further the Rhode Island's Constitution, and that required voter approval. Benson versus McKee, 273 A.3D 121, Rhode Island 2022. The Supreme Court of Rhode Island summarily dismissed the suit. The Superior Court of Rhode Island summarily dismissed the suit. They're saying none of the plaintiffs had standing. So they appealed, and the Supreme Court of Rhode Island affirmed the lower court. The adults couldn't establish that the RPA required voter approval, and the preborn children couldn't establish personhood. The rejection of personhood is the key. The Rhode Island Supreme Court relied on Roe v. Wade to deny personhood to the preborn plaintiffs. The Rhode Island Supreme Court filed their opinion on May 4th, 2022, but something had already happened 2 days before that should have prompted that court to stop the presses. That something was the big leak of Justice Samuel A. Alito's first draft opinion, in Jobs versus Jackson Women's Health Organization. As everyone now knows, that opinion flatly repudiated Roe. We still don't know who leaked that draft, but we do know Alito's reasoning. Basically, he said the Roe court and the Casey court after it didn't have a constitutional leg to stand on. But Justice Alito did not say that the preborn child is a person. He said only that the Constitution does not protect any right to end a pregnancy. Now, Mr. Benson and his fellow plaintiffs petitioned the Rhode Island Supreme Court for re-argument on May 16th. In their petition, they said the big leak gave every reason to doubt that Roe would remain a binding precedent. The Rhode Island Supreme Court refused re-argument, but as everyone knows, the Dobbs case came down on June 24th. Justice Alito's opinion survived virtually intact, except maybe for the striking of a two-word interjection. You remember the words, 0 and none. Well, on that basis, the two advocates for the preborn and Catholics for Life petitioned the U.S. Supreme Court for review. I've left links in the description to where you can read their petition brief and their appendix. I'm also going to leave a link to Steve Ertel's article in Life News. Now, I don't usually link to reportage in my descriptions here, but this article is a cut above. It has an excellent discussion of briefs contending that a preborn child is a person. Why those briefs didn't make it into the U.S. Supreme Court's record on the Doe case, I don't know. These two friends of the court briefed on the Dobbs case, but not on the Doe case. Now, maybe that's against the rules of the court. Maybe you can only brief on a case after the court grants certiorari on it. Maybe one of you legal eagles out there can leave a comment and let me know. Well, I'd really like to know. Now, when Dobbs came down, I said then, and I repeat today, the Dobbs majority might split on the question of an affirmative right to life for the preborn. Before I discuss how they might split, I want to shout out to a sponsor who can really help you through the economic storms to come. That sponsor is oursilverlines.com. Do you feel like you're working harder for your money just to get by? You are not alone. The fluctuating economy, employment issues, and unexpected changes in life have left many families struggling over the past few years. Now, collecting gold and silver can help shield you against many of these challenges. But if you're like me many years ago, you don't know where or how to start. Our Silver Lines helps by connecting you with thousands of members who are learning the secrets to creating and protecting true wealth by collecting precious metals. Now, whether you just want to collect rare and unique coins, or you want to take advantage of the business opportunities that company provides, they can help you learn to live an exceptional life. Visit oursilverlives.com. Learn how you can build a legacy for your future. Now, again, we know only that fewer than 4 justices would have granted certiorari in the case of Doe versus McKee. It takes 4 justices to grant certiorari and 5 to decide a case. 5 justices, meaning Chief Justice Roberts and Justices Barrett, Gorsuch, Kavanaugh, and Thomas, joined Justice Alito in Dobbs. So, of those 6, who would have been most likely to grant the petition? Well, for that, we must read the opinion in Dobbs. Justice Alito gave the opinion of the court. Justices Barrett and Gorsuch wrote no concurrences. But Justices Thomas and Kavanaugh and Chief Justice Roberts did. So, let's look. Justice Thomas becomes the most staunch candidate to declare a right to life for the preborn. His concurrence strongly suggests that he compares preborn children today to the slaves before the war between the states. Indeed, his entire jurisprudence bristles with references to Dred Scott versus Sanford as the worst error the court ever made. Chief Justice Roger B. Taney denied standing to Dred Scott. If preborn children are today's Dred Scotts, Clarence Thomas would definitely want to grant them standing. Chief Justice Roberts would not. Remember, he tried to protect Roe by finding that a 15-week developed preborn child was viable. Brett Kavanaugh, in his concurrence, dropped hints that he might not grant standing either. That would go to his not wanting unelected justices to decide moral issues. Justice Gorsuch has left no clue in his jurisprudence as to where he would stand on matters of life. Justice Barrett has left clues in her earlier jurisprudence and her personal life. If any justice would join Justices Thomas and Alito in granting standing to preborn children, she would. But Gorsuch is less likely. Again, 6-3 against, result cert denied. Jesus tells a parable about an unjust judge who nevertheless grants a widow's petition just to stop her pestering him. Luke chapter 18, verses 1 through 8. That gives us clues to what to do next. Don't give up. For 49 years, pro-life advocates petitioned the court repeatedly. We also saw the March for Life that always finished on 1st Avenue Southeast in front of the court. Next year, for the first time, they're going to finish in front of the Capitol, not the Supreme Courthouse. The Supreme Court, in its 2021 term, did more than remove a federal constitutional right to end a pregnancy. They also declared that people of faith deserve freedom to worship publicly and equal consideration in the public square and the administration of government programs. But those are only the first steps. Perhaps the next generational change to the court must be a Bible-believing court that boldly declares the reality of God and that he supersedes even the Constitution to confer the full right to life on all human beings, regardless of stage of development. Now, how long do you think that's going to take? Well, maybe not as long as people think. Remember, citizens on the political left and right do not reproduce at the same rate. Conservatives do all the things liberals don't. They marry, start families, keep their babies, and raise their children. Already, people are sorting themselves out among the several states according to political viewpoint. California lost a seat in the House of Representatives on the strength of this great sortation. Well, the sad part is this is going to polarize the states according to political viewpoint. Virginia already has become a battleground, and it will have to decide in this next off-year election what kind of state it's going to be. Delegate Elizabeth Guzman, Democrat, what else, from Prince William County, Virginia, hinted 2 days ago that she would introduce a bill to bring misdemeanor or even felony charges against parents who refuse to consent to puberty blockers or sexual reassignment surgery for their children. She told that to station WJLA-TV Channel 7, Washington, D.C. Last night, a different Washington, D.C. station, WUSA-TV Channel 9, reported that Delegate Guzman had taken that back. But her counterparts in other states might move forward with bills like hers. But within a generation or two, political power in many blue states is going to shift as rural populations out-reproduce the urbans. That shift will change the Congress and also the nation's law schools and through them, the judiciary. And in the meantime, conservatives should press their states to repeal their Blaine amendments and bring back sound moral education. Link in the description of the article to the docket listing, petition brief, and appendix for Doe versus McKee, to the Life News article, and to Conservative News and Views. I've also left links to the awesome CNAV Store and to ourcivilliance.com, as I also mentioned. You know already about how to like a video, turn on notifications, and leave a tip. On the end screen, I'm going to leave a subscribe link, and also to links that I have done earlier on the subject of Dobbs versus Jackson Women's, and what pro-life people ought to do next. This is Terry A. Hurlbut delivering another declaration of truth and reminding you to let the truth set you free.